Next, the multiple choice question is voluntarily. It has been defined as an effect caused by means whereby a person intended to cause it, or by means at the time of employing those means know or had reason to believe to be likely to cause it under which section it is coming. It is coming under section 39 of IPC, or otherwise under section 2 subsection 33 of BNS. In BNS, in section 2 subsection 33, voluntarily has been defined. The definition is given in the question itself. It is an effect caused by means whereby a person intended to cause it, and so and so. Voluntarily means which you are doing at your own will, without having any coercion or inducement or any pressure from outside. If you are doing anything, knowing the consequences of that particular thing, voluntarily, at your own free will, then it is voluntarily. If a person puts a knife on my neck and asks me to force open bank locker, it is not voluntary. If I pick up a stick and beat some other person without anyone forcing me to do that thing, then it is voluntary. Next, under section 45 IPC or section 217 of BNS, life denotes. Life definition has been given. It is life of a human being. Here, section 217 life has been defined as it means the life of a human being unless the contrary appears from the context. That means any human being's life is called life. It has been defined in the BNS as well as in IPC. Under section 46 of IPC, section 2, subsection 6, death denotes. Here, death definition has been given. Death of a human being. Section 2.6, death means the death of a human being unless the contrary appears from the context. Next, illegal signifies. Illegal means everything which is an offense. Again, it is a definition. Illegal means everything which is an offense. Everything which is prohibited by law. Everything which furnishes a ground for civil action. All the above. The answer is D. We have to remember when we are understanding the definition of illegal, it means it has got three components. It must be an offense, and it has to be prohibited by law, and it can give a cause for civil action. Now we will see what has been defined in the BNS. Section 215, illegal and legally bound to do. Both these words have been defined in section 2, subsection 15. The word illegal is applicable to everything which is an offense or which is prohibited by law or which furnishes ground for a civil action. That means any one of these three elements. Either it may be an offense, or it may be prohibited by law, or it may be a ground for civil action. If any one of these three conditions will meet, then it is illegal. And again, legally bound to do. It has also been defined. Whatever it is illegal in him to omit. Here, legally bound to do is denoting omission. We have already understood offense means either it is commission or omission. In the first part of this definition, commission has been deployed. In the second part, omission has been deployed. Here you see the word illegal is applicable to everything which is an offense. It is commission. It is doing some act. It is not an omission. Which is prohibited by law. Again, it is commission of an act and which furnishes ground for a civil action. But in the second case, in the second part of this definition, if you omit which you are legally bound to do, then it is also an offense. For example, a prisoner has got a legal duty to provide food to the prisoner at regular intervals. If the jailer abdicates his responsibility and if he will not provide food to the prisoner at the regular intervals, then it is omission, which he has legally bound to do, he did not do, and he omitted to provide food at the regular intervals to the prisoner. Next, animal. Animal, again here definition. Animal is defined in section 2, subsection 2. You see in BNS, the definitions have been given in alphabetical order. Section 2, subsection 1 is act. Section 2, subsection 2 is animal. In this way, it has come. Animal means any living creature other than human being. Human being has been excluded. Any living creature, including human being, any living creature other than human being. B is the answer. It is completely tallying with the definition of what we had read just now. And next question is, nothing is said to be done or believed to be done in good faith, which is done or believed without due care and attention, is the definition of good faith contained in. He is asking the section of good faith in BNS. It is section 52 of IPC. Here in BNS, it is section 211. Good faith has been defined. Here, what we have to remember is, nothing is said to be done or believed in good faith, which is done or believed without due care and attention. That means, if you want to show good faith, we have to show due care and attention. This phrase you remember. Due care and attention. Because in the multiple choice questions on several occasions, this particular phrase has come. It has, if you don't show any due care and attention, you have not shown good faith and it is a bad faith. Who was the president of the drafting committee of the Indian Penal Code? Answer is Lord Macaulay. This type of question may not come because IPC has become redundant. Next. Under which name the Indian Penal Code came into application in Jammu and Kashmir? The answer is Ranbir Penal Code. Now it is not there because once BNS has come, BNS has been extended from Kanyakumari to Kashmir. That's why even in the case of Jammu and Kashmir, this BNS will be applicable, not that Indian Penal Code or Ranbir Penal Code. Which of the following is the principle applied in construing a penal act? This type of question we had already done it. Again, we are doing it. It is a very important question. If in any construing the relevant provisions, there appears any doubt of ambiguity. Ambiguity means not clear, unclear, a doubt. It will be resolved against the person who would be liable to the penalty. The person who would be liable to the penalty means the accused. Whether any doubt is there in any particular phrase in the law, in the criminal law, how it has to be interpreted by the court, whether it should be done in favor of the accused or it should be done against the accused. The answer is always, if there is a doubt in any provision, that interpretation must be done by the honorable courts in favor of the accused, not against him. That's why A is not correct answer. Second is the correct answer. If in any construing the relevant provisions, there appears any doubt of ambiguity, if the word is not clear, if the provision is not clear, it will be resolved in favor of the person who would be liable to the penalty. In favor of the person who would be liable to the penalty. It shall be interpreted in favor of accused. Next. Actus non facit review, nisi mens sit rea means. This Latin phrase, you have to understand the full meaning of this thing because time and again this type of questions are coming. The answer is the intent and act must both concur to constitute the crime. The mens rea as well as actus reus both will concur to each other. Then only the crime will be there. That means crime has got two parts. The constituents of a crime are two things. One is criminal intent and the criminal act. Mens rea and actus reus. They both concur. Then only crime will happen. Literally, mens rea means guilty mind. Yes. A guilty or a wrongful purpose. Yes. A criminal intent, a guilty knowledge, and willfulness. It is also correct. All the above. Mens rea means all these three things. Even though a man's knowledge that a particular consequence will probably result from his act is sometimes an insufficient basis for saying that he intends it, there are strong reasons for holding that as legal matter he can be held to intend something that he knows for sure he is doing. That is called skewed intent, means tilted intent. Oblique intent, that means indirect intent. Hypothetical intent means assuming intent. Square intent exactly fits, exactly similar thing. Now, in the case of mens rea, the correct answer will be, it will be always indirect intent. Intent cannot be perceived. Intent can be found out by backtracking from the crime. Once a crime will happen, we will go back and try to find out the intent. That may not be always direct. Sometimes it will be indirect. But in the case of these things, skewed intent will not be there. Skewed means tilted event. From straight line, if it tilts to left or it tilts to right, then it will be called skewed intent. Next, hypothetical intent means that you are assuming the intent. It will not be permissible in criminal law. Intent must be shown to the court that there is a criminal intent on the part of the accused. Next, square intent. Square intent means the intent what the accused had breeded in his mind. It must be completely meet with the actual incident. Square intent means exactly something agrees. Here we see oblique means not expressed or done in a direct way. Indirect way it has been shown. Square means to agree with something. It has to be agreeing with something exactly to make sure that something agrees with something. Here the correct answer is oblique intent because mens rea will be most of the times indirect one. Sometimes a direct intent can be perceived, can be observed, can be seen. Next, in which of the following cases mens rea is not an essential ingredient for offences under? We have already seen socio-economic cases, mens rea is not required. Again, I am telling, mens rea is not required doesn't mean mens rea is not existing. Mens rea is not essential means the prosecution shall not be burdened to prove mens rea. In certain cases, it is the responsibility of the accused that there is no mens rea. In revenue cases, in public nuisance cases, in criminal cases, which are in summary mode, then actually this mens rea need not to be proved by the prosecution. Only the accused has got the responsibility that there is no mens rea. That's why there is no crime. Even though if mens rea cannot be seen by the court in revenue matters, in public nuisance matters, the court may hold him guilty because in these cases, mens rea is not an essential thing. Revenue cases, public nuisance, criminal cases which are in summary mode. What is this summary mode? When we study BNSs, we will see one sessions trials. That is completely different and distinct one. In very serious offences, where the punishment is more than 7 years, the matter goes to sessions court. In all other cases, where the punishment is less than 7 years, 7 years or less than 7 years, the matter goes to Chief Metropolitan Magistrate, Chief Judicial Magistrate or Additional Judicial Magistrate, like that. Now, what is this summary proceedings? In the case of Chief Judicial Magistrate and his subordinate judicial magistrates, they will try 3 types of cases. One is a warrant case, second one is summons cases, third one is summary cases. Which are warrant cases, which are summons cases, those have been described in BNSs. But in some stages, if a summary case, if a summons case, the court treat it not very serious one, it may conduct the trial in summary mode, means in a very quick manner. But there is a condition. If the court decides to conduct a case in summary mode, that it cannot impose punishment more than 3 months. That is the mandatory thing. If he wants to impose a punishment for more than 3 months, if the trial court wants to impose a punishment more than 3 months, then he has to change it from summary mode to summons mode. That you have to remember. In summary mode also, mens rea is not required because the punishment that will be imposed is less than 3 months. That's why mens rea will not be insisted. Next, presumption of a culpable mental state of a person as per Section 10C of the Essential Commodities Act 1955 includes presumption of culpable mental state of a person as per Section 10C of Essential Commodities Act means this act comes under socio-economic offenses. It is an economic offense. Section 10C of Essential Commodities Act deals with the presumption of a culpable mental state. There is a presumption of a culpable mental state in prosecutions for offences under the Act that require such a mental state, allowing the court to presume its existence unless the accused proves otherwise. In the earlier question, I have completely explained. In general principle is that prosecution has got the responsibility to prove mens rea. But in socio-economic cases, in cases where mens rea is not required, the court presumes that there is mens rea on the part of the accused. The burden will shift from prosecution to accused. Now, the accused has to prove that there is no mens rea. The presumption, the court shall not draw any presumption. There is no mens rea. That's why no offense has been committed. That responsibility lies on the accused. Answer is D. 1, 2, 3, and 4. Presumption of culpable mental state of person as per Schedule 10C of the Essential Commodities Act includes. What is this culpable mental state? Intention, motive, knowledge of fact, belief in or reason to believe a fact. All these 4 things are part of mens rea. culpable mental state. Now you may ask a question. While explaining mens rea, I told you motive is not required. It is not an essential ingredient in mens rea. But why it has been given here? Because motive is a key thing to intention. It is an engine for intention. A motive starts and it creates intention in the mind. That's why motive may not be very essential ingredient to prove a crime because from intention we start. Intention, preparation, attempt, and finally completing the accomplishment. All these four stages of the crime are there. In that, motive is not there. But motive always plays a hidden role in mens rea. Here the answer is D because all these four are important in the presumption of culpable mental state. When a court draws that there is a presumption on the part of the accused, so far as mens rea is concerned, the court sees intention as well as motive and as well as knowledge of fact and also belief in or reason to believe a fact. The question whether a corporate body should or should not be liable for a criminal action resuming from the acts of some individuals must depend upon nature of the offences disclosed by the allegations in the complaint or in the charge sheet, the relative position of the officer or agent vis-a-vis the corporate body. Third, other relevant facts and circumstances which could show the corporate body as such meant or intended to commit that act. Next, all of them. I have twice or thrice explained about the definition of a person. Section 2, subsection 26, a person is defined. It includes any company or association or body of persons. Company can be an accused. If company will be an accused, if any criminal act will be done by some individuals, how the company will be liable for the act? First option is nature of the offense disclosed by the allegations in the charge sheet or in the FIR or in the complaint. Nature of the offenses disclosed by the allegations in the complaint or in the charge sheet. Okay. Next, the relative position of the officer or agent vis-a-vis the corporate body. The relationship between the corporate body and officer has to be shown. The nexus has to be shown. Any stranger to the corporate body, he cannot be made an accused in an offense committed by a corporate body. The officer has to be close nexus to the corporate body. Other relevant facts and circumstances which could show the corporate body as such meant or intended to commit that act. Other relevant factors relating to that offense has been committed. Those have to be shown. All of them. The answer is all of them. Which of the following is false about the presumption of innocence? 4 options have been given. The question is asked about falsity. False. That means 3 are right and 1 is wrong. We have to find out the wrong one. Presumption of innocence. This holds good in all kinds of trials, including criminal trials. Yes, in this case, the crime must be brought to a prisoner, accused. It is also correct. It can be easily rebutted. No. You ask any prosecution, it is the most difficult thing under the sun to rebut the innocence. Accused has got the luxury of a presumption of innocence. When he will be brought before the court has to believe that he did not do any crime. Now it is the responsibility of the prosecution to prove that he has got mens rea and that he has done actus reus. And it is very difficult. It is very difficult. That's why the answer is it can be easily rebutted. It is wrong. It is very difficult to prove the presumption of innocence. Graver the crime, graver will be the degree of doubt that is reasonable. Yes. If the crime is greater in degree, the doubt will be greater in the mind of the court. In the case of murder, in the case of rape, in the case of heinous crimes, the court has got graver doubts. In the case of theft, the court may not have that much of high level of doubts. Next, under which section of the IPC a person, irrespective of his nationality, can be held guilty and is liable to punishment for any offense within India? He is asking the questions, sections. That means you have to remember all the sections.